We're now going to start with the Court of Appeals 1926 case, which is the first case in this trilogy of Berkey versus Third Avenue Railway Company. Mrs. Berkey was riding a railway car that was operated by the 42nd Street Railway Company. The car came to a stop at the corner of 117th and Broadway, and Mrs. Berkey alighted from that car and stepped directly into a 26-inch pothole filled with rocks and was injured. Mrs. Berkey wanted to sue somebody for her injuries. The problem is that the company that operated this particular streetcar, 42nd Street Railway Company, didn't really have much in the way of assets. The assets were largely leased or provided by its majority shareholder, the Third Avenue Railway Company. So Mrs. Berkey sued the Third Avenue Railway Company, seeking to recover from Third Avenue for her injuries. Third Avenue moved to dismiss the complaint on the grounds that 42nd Street's liability should remain with 42nd Street Liability. The motion court granted the motion to dismiss, and Mrs. Berkey appealed to the First Department. The First Department found that the following factors showed that there was a lot of overlap and perhaps domination and control of 42nd Street Railway by the Third Avenue Railway Court. Third Avenue consolidated 42nd Street on its balance sheets. Third Avenue held most of 42nd Street's debt. There was an overlap in officers and directors between the companies. Third Avenue owned all the cars, which were all marked Third Avenue Railway System, and Third Avenue paid for equipment, salaries, and electricity. So on that basis, the First Department allowed Mrs. Berkey to pursue her claim directly against Third Avenue Railway. Third Avenue Railway appealed to the Court of Appeals, and the Court of Appeals started with the following. The Court of Appeals said that yes, dominion may be so complete, interference so obtrusive, that by the general rules of agency, the parent will be a principal and the subsidiary an agent. The court then went on to say where control is less than this, we are remitted to the tests of honesty and justice. So it really looks like the court here is saying there's two avenues to piercing the corporate veil. One is if you show domination and control such that an agency relationship exists, and typically the principal will be liable for the actions that the agent takes within the scope of its agency. But in the event that you can't show agency, we're remitted to the tests of honesty and justice.